Good morning, everyone. I hope you're all safe and well. My name is Jerry O'Hare and I'm a Senior Associate at Law at Work. Some of you may know me from previous training and some may even be clients. For those that don't, hello and welcome. We'll be joined later by my colleague Douglas Cameron, who's the head of Law at Work's Health and Safety Division, but because of social distancing, we are in different rooms at the moment, but Douglas will be joining me later on. So this morning, I will be concentrating on the HR and employment law considerations of a return to work from furlough, and Douglas will come at it from a health and safety perspective. Before we get started, if I can ask someone just to type in a little message into the comment box to let me know that you can see and hear me okay, that would be much appreciated. Great, lots of messages. Thanks, everyone. That is, wow. Great, thanks for that response, guys. So what I'm going to do now is I'm going to share my slides with you. So if you bear with me one moment, I'm just going to do that. So what are we going to consider today? As you can see from the first slide, which I've deliberately kept fairly limited today, I don't want to inundate you with too much information. But today I'm going to be looking at, first of all, a return from furlough and what that might look like. I'll then be moving on to look at home working and also the legal risks. So first of all, a return from furlough. Let's consider preparing for a return to work. Many organisations in the UK have made use of the government's coronavirus job retention scheme to maintain their workforce during the outbreak. The Chancellor announced on Tuesday that the scheme will continue unchanged until the end of July and that it will be extended until the end of October, although we don't yet quite know what it will look like between the months of August and October. However, I think what is clear is that it will become more flexible by making it for people to work part-time and still have their wages topped up by the state, and that from August, businesses will be asked to share some of that financial burden. The government will be announcing further details of this at the end of this month, and so I'm afraid we'll have to wait until then to find out how all this will actually work in practice. In the meantime, some employers may be considering whether some of or all of their workforce can return to work before the end of the scheme, depending on whether restrictions are lifted to allow more workplaces to reopen, while others may be planning to keep employees on furlough until the end of the scheme and will be considering how a return to work should be managed at that point. Well, as a starting point, I think a good place to start is for employers to examine letters or agreements confirming furlough arrangements to determine what steps they should take to communicate with employees. If the furlough period comes to an end in accordance with the agreement, or if the employer retained the right to require the employee to return, the employer will simply need to contact the employee to confirm a return to work. However, if the employer wants to require the employee to return early, and this is not provided for in the agreement, then it will need to agree an earlier return with the employee. One of the key considerations for employers seeking to reopen before the end of the scheme will be to decide whether some employees should remain on furlough due to their own particular circumstances. For example, employers may wish to adopt a policy whereby those who are shielding or who live with someone who is shielding remain on furlough for the duration of the scheme. Other groups to consider are those who have childcare responsibilities, making a return to work difficult, and those who are vulnerable but do not require to shield, i.e. if they have underlying health conditions or are over 70 or perhaps are pregnant. Employers will need to balance their resourcing needs with their obligations to protect health and safety and, of course, avoid discriminatory treatment. Employers will also need to consider any employee relations issues arising between employees who have been furloughed and those who have continued to work, either from at home or at the workplace. Many of those who have been able to continue working have been doing so under difficult circumstances, and therefore employers should be alive to the potential tensions between the different groups. And if possible, employers should aim to prioritize employee well-being and try and foster an inclusive atmosphere. But what about health and absence on a return to work? It's important that employers managing a return to work, either after furlough or when the restrictions are lifted, ensure that employees are fit to return and remain fit to be at work. Some employees may be unable to return due to sickness or because they're in a government-advised shielding or self-isolation category. In addition, some employees may go on to develop symptoms or require to self-isolate in the coming weeks and months. So employers should consider how these absences will be managed. Other employees may be particularly nervous about returning to work, and so employers should consider what action to take should they face resistance from employees about returning to the workplace, and I'll come on to all of this shortly. One option is for employers to write to employees setting out its approach to absences during the coronavirus crisis, including whether or not statutory or company sick pay will be paid, or whether the employee will be placed on unpaid leave. It's recommended that employers should also tell employees what steps they should follow if they develop symptoms or fall into a government-advised self-isolation category. This should include guidance on what symptoms to be aware of, whether employees should attend work or work from home, how absence should be reported, and how contact should be maintained during absence. In terms of isolation, as we should all know by now, an employee needs to self-isolate if they or anyone else they live with has symptoms of COVID-19, i.e. a high temperature or a new persistent cough. And those with symptoms must self-isolate for 7 days. However, if someone in their household has symptoms, they must isolate for 14 days. Instead of obtaining a fit note from their GP, employees should obtain an isolation note from NHS 111. And if the employee feels better after 7 days, they may return to work. However, if the symptoms worsen, the employee should use the online NHS tool to seek advice, or if necessary, call NHS 111. And of course, in the case of medical emergencies, employees are best advised to call 999. Our advice is that employers should clearly communicate their policy for pay on sickness absence. As a minimum, those who are sick or self-isolating with COVID-19 are entitled to statutory sick pay from day 1 of absence. Some employers may also operate contractual sick pay schemes in addition to SSP. Contractual sick pay will almost certainly apply during sickness with COVID-19, but it is unlikely that it will apply if the employee is self-isolating because they live with someone who has the symptoms. That being said, employers may well wish to extend their contractual sick pay to self-isolating employees in these circumstances. In the situation where an employer operates a discretionary contractual sick pay scheme, it should consider outlining to employees when discretion may be applied and confirm whether there will be any review of discretionary sick pay depending on the business's resources. But what about shielding employees? Employees who are particularly high risk of developing complications should they contract the virus have been advised to shield from it. Individuals in this group include solid organ transplant recipients, people with specific cancers, and women who are pregnant with significant heart disease congenital issues. Initial advice to those in the shielding group was that they should remain at home and not leave for any reason for at least 12 weeks. As the pandemic progresses, it may be the case that the government extends this timescale and advises these particularly vulnerable individuals to shield for longer. Employers should have regard to any government advice about shielding employees, but they are still entitled to manage shielding employees' absence. Indeed, it's advisable for employers to follow normal processes in scheduling welfare meetings to ensure that employees are kept up to date with developments. However, at present, any absence management should not be with a view to dismissing the employee or issuing warnings. At this stage, it is our view that it is highly unlikely that dismissing a shielding employee on the grounds of absence will be legally fair, although much will depend on the individual circumstances and the length of the shielding period. In addition, employers should be aware of potential disability discrimination claims. Instead, shielding employees should be permitted to remain off work and will be entitled to SSP from day one of their absence. Shielding is currently only a recommendation, meaning that an employee may still attend work should they choose to do so. If an employer decides that they do not want the employee to come into work on medical grounds, then medical suspension on full pay could be considered. The specific statutory meaning of suspension on medical grounds refers to legislation giving employers the right to suspend employees on full pay if their health and safety are in danger. For example, from certain substances which are hazardous to health, and certain chemicals and lead to carrying poisonous risks. Employees are suspended for their own protection. This specific type of suspension does not cover the coronavirus situation, although the legislation could be amended so that it does. The second meaning of medical suspension, or suspension on medical grounds, is a generic reference to an employer's decision to suspend employees for medically related reasons to protect other staff. This type of suspension can potentially apply in the coronavirus situation. If an employer chooses to suspend employees for a brief period, then as long as this is on full pay, the suspension is likely to be permissible. The employer's ability to suspend an employee in the coronavirus context is primarily contractual. For example, staff refusing to accept medical advice to self-isolate. Pre-existing standard clauses in contracts of employment or disciplinary policies are unlikely to expressly cover the coronavirus situation. However, there is an implied contractual duty to ensure health and safety of employees. Instructing an employee not to attend work on full pay is likely to be deemed reasonable if there are rational grounds for the decision, such as trying to prevent the spread of the virus to non-infected employees. What about pregnant employees? Well, pregnant employees don't generally fall into self-isolation or shielding categories, but nonetheless, they have been strongly advised to socially isolate, avoid traveling on public transport, and work from home where possible. Employers have a specific duty to protect the health and safety of pregnant employees and should carry out specific risk assessments to assess whether or not any adjustments to the role are required. The Management of Health and Safety at Work Regulations, 1999, requires employers to, 1, assess the workplace risks posed to new or expectant mothers or their babies. 2, alter the employee's working conditions or hours of work to avoid any significant risks. 3, offer suitable alternative work on terms that are not substantially less favourable, where it is not reasonable to alter the working conditions or hours, or would not avoid the risk. And 4, suspend the employee on full pay where suitable alternative work is not available or the employee reasonably refuses it. As a result, if a pregnant employee is not able to work from home, her role cannot be adjusted to reduce the risk posed by coronavirus, and the employer does not have suitable alternative work for her to do, then the employer should consider medically suspending the employee on full pay. Employers should also be mindful of the risk of discrimination claims from pregnant employees. So I've spoken about shielding and pregnant employees, but what about employees who are nervous about returning to work? And let's be frank, lots of people will be nervous about a return to work. Well, these employees are likely to be those who are more vulnerable to complications, but some may be nervous for other reasons. For example, because of concerns about potentially exposing someone they live with to the virus, or because of anxiety-related disorders. These employees do not neatly fall into an authorised absence category. However, in light of the extraordinary circumstances created by the outbreak, employers should take a reasonable and open-minded approach to these employees, including understanding any medical issues. In addition, if the reasons for non-attendance stem from age or disability, either of the employee themselves or their association with a disabled person, then the employer should be mindful of the risk of discrimination claims. So what steps should you take if you have an employee refusing to return to work? Well, I'd suggest that a good first step would be to speak to the employee who's refusing to understand their reasons for refusing. The employer should explain what steps it has taken or will take to protect health and safety, and consider any further suggestions that the employee may have which will help them return to work. If feasible, home working, reduced hours, a different working pattern, or amended duties should be explored. Ultimately, if the employee continues to refuse to return to work, the employer could permit the employee to take unpaid leave, possibly combined with some annual leave for a period of time. Given that it's not clear when the outbreak will resolve to the point where normal life can resume as before, it would be sensible to review this arrangement regularly to determine whether or not it can continue. If the situation continues indefinitely, it is possible that the employer could be in a position to dismiss fairly on the grounds of capability, or because the employee refuses to follow a reasonable management instruction to return to work. However, we would recommend that employers seek legal advice before proceeding down this route. If the employee's objections are based on health and safety concerns and they're subsequently dismissed, it may be possible for them to bring a claim for unfair dismissal related to health and safety breaches, or a whistleblowing claim, as well as possible discrimination claims. And I'll come on to talk about these shortly. Finally, before coming on to talking about managing holiday entitlement, what about managing a return to work for working parents and carers? Well, managing a return for work for those who have childcare responsibilities may be particularly difficult in the coming months. At present, the government has not indicated when schools and nurseries will fully reopen, although this will be done on a phased basis. Whatever methods used to open schools and nurseries, it's likely that some disruption will continue, which will have an impact on working parents and carers, many of whom rely on informal childcare through grandparents or other networks, and it is likely that these options will not be readily available in the near future. The first step for employers will be to determine which employees are likely to have particular difficulties. To do so, employers could consider including questions about caring responsibilities which would make returning to work difficult to return in a return to work questionnaire. Each case will likely have to be considered on an individual basis based on the employee's circumstances and the nature of their role. Employers should discuss the matter with their employee and explore any viable options to aid a return to work. This could include, for example, home working, reduced hours, a different working pattern, or even amended duties. If a return to work in any form is impossible, employers should consider whether they can continue to make use of the job retention scheme to furlough employees, or whether arrangements need to be made to allow for a period of unpaid leave, possibly making use of annual leave to cover some of the absence. Employers should also bear in mind that employees have a statutory right to take up to 4 weeks statutory parental leave per year if they have more than 1 year's continuous service and have parental responsibility for a child under the age of 18. Leave is unpaid, although in some rare circumstances, some employers do offer it as paid, although this is quite rare. And employees are entitled up to 4 weeks per year per child. Note that the dismissal of an employee who is unable to return because of childcare responsibilities is unlikely to be fair at this stage. Some form of school attendance is likely to be possible in the coming months, meaning that employees may be able to revert to normal working patterns. Employers, we suggest, and we would hope employers would, remain open to flexibility in the meantime. Coming now on to managing holiday entitlement. Well, believe it or not, this is one of the most common queries we've had from clients over the last couple of weeks. And the government, realizing this is such a hot topic, issued guidance on this, further guidance on this as recently as yesterday. So staff continue to accrue annual leave as normal while under contract with an employer. Normally, employees are required to use or lose statutory annual leave, 5.6 weeks for a full-time employee, in the year in which it accrues, unless you're on a form of family leave or in some circumstances have been unable to take holidays due to sickness. Any employees who have been working from home, on furlough leave, sick leave, isolation leave, or unpaid leave will have built up holidays during this time, which may cause issues if employees return to work with a high number of holidays still to be taken. Note that holidays can be taken on furlough without jeopardizing the employer's access to the coronavirus job retention scheme funds. One option to prevent a large amount of holiday build-up without being taken is to give notice to employees requiring them to take leave on specific dates. There are no specific requirements about the form that this notice must take, but the important part here is that this notice must be at least twice the length of the period of leave that the employee is being ordered to take. So for example, if you want to require an employee to take a week's leave, you must give them at least 2 weeks advance notice of this. Another option is to allow employees to carry forward holidays to the next holiday year. The government has recently amended the working time regulations to allow statutory holidays accrued this year to be carried forward for up to 2 years where it was not reasonably practical for staff to take leave during the outbreak. The carryover amount will be limited to 4 weeks statutory leave, and statutory holidays above this amount, i.e. 1.6 weeks for full-time workers, should be taken this year. Finally, it's open to employers to make different arrangements in relation to contractual holidays over and above the 5.6 week minimum statutory entitlement. The way in which these holidays are taken is a matter for agreement between employers and employees. Some employers already allow carryover of contractual leave from one year to the next. An employer could allow for more leave than usual to carry forward, or could agree that employees will sacrifice the right to take these holidays and will instead receive a payment in lieu of them. Note, however, that employers are not permitted to pay in lieu of statutory holidays except on termination of employment. The final bullet point on this slide is that of redundancy. While businesses will welcome the opportunity to reopen workplaces and try to establish a new normal to allow operations to continue, it may not be possible to avoid cost-saving measures such as compulsory redundancies or even a change to terms and conditions. And unfortunately, I've had a number of clients over the coming weeks who are now having to take steps, or at least consider having to make redundancies. I'm not going to discuss redundancy this morning because it's a big topic, but I'm pleased to say that we'll be hosting separate webinars in the coming weeks. The first one being on managing redundancies, and that will be on the 21st of May, and then one the following week on collective redundancies, because of course there are special rules in place where 20 or more employees are possibly going to be made redundant. And that collective consultation webinar will be taking place on the 28th of May. All of the details of these webinars are on our website, and you just sign up as you did for this morning. I'd now like to turn attention to the various legal risks which may arise when returning to work in the current climate. In the context of the coronavirus outbreak, the risk of a discrimination claim being raised primarily arises in relation to vulnerable employees, i.e. those who are older, have underlying health concerns, or those who are pregnant. Looking at discrimination, first of all, before coming on to the others, discrimination, as you should or hopefully know, can take various forms. For example, direct discrimination. Direct discrimination occurs where someone is treated less favorably because of a protected characteristic, and this is more likely to arise where decisions have been made specifically on the basis of a person's protected characteristic. Employers should be alive to potential direct discrimination when managing individual cases of absence, for example. An example here would be dismissing an older, disabled, or pregnant employee solely for refusing to work on these grounds. Indirect discrimination occurs where someone is disadvantaged by an unjustified provision, criterion, or practice that also puts other people with the same protected characteristic at a disadvantage. Employers should be particularly conscious of the risk of that indirect discrimination when implementing new policies or procedures as a result of the virus. An example would be a decision to place only those with a disability on unpaid leave, where others who are unable to return are permitted to work from home. In addition to direct and indirect discrimination, there are two forms of discrimination claim that can be raised which are specifically in relation to the protected characteristic of disability. The first is what's known as discrimination arising from disability. And this occurs where an employee is treated unfavorably because of something that arises in consequence of their disability. So in the context of the coronavirus situation, the decision to self-isolate could be something which arises in consequence of disability, and unfavorable treatment could be dismissing or disciplining an employee for that reason. The second is a failure to make reasonable adjustments. Employers are required to make reasonable adjustments where there is a particular barrier, whether it be physical or not, which puts disabled people at a disadvantage. What is reasonable will depend on the facts of each and individual case. In the context of coronavirus, this obligation is most likely to arise when employers are managing a return to work or requiring those with a disability to work from home. And so employers should take reasonable steps to alleviate any difficulties faced by those who have a disability. Where an employer is unsure about whether or not an employee could be considered disabled, we always say to clients that it's very advisable that they should seek medical evidence from a specialist, whether or not that is a GP, the employee's GP, or my preference, which is an occupational health specialist. Advice should be sought on both the nature of the employee's condition and also on any adjustments to the workplace or the employee's role that may be required to comply with the employer's duty to make reasonable adjustments. Turning now to look at whistleblowing. Whistleblowing claims can be raised when an employee makes a protected disclosure and is either dismissed or subjected to a detriment as a result. Protected disclosures can be made on a range of issues, but in a COVID-19 world, the most relevant disclosure made would be on the grounds of a danger to the health and safety of any individual. The disclosure itself can be made verbally or it can be done in writing, and there's no particular format that an employee must follow. Employers are well advised, therefore, to be careful. Disclosures are usually made directly to the employer, often through a grievance or a complaint, but it can be made to other external parties or bodies, such as the health and safety executive. The whistleblower must have a reasonable belief that what they disclose is true, even if it transpires that what is disclosed is not accurate. If an employee is dismissed because they have made a protected disclosure, they may raise a claim for unfair dismissal, but they can also raise a claim if they have been subjected to a detriment. Whether or not something is a detriment depends on the facts of each case. However, it can include disciplinary action being taken against the employee. In the context of coronavirus outbreak, employees who complain about returning to work on the grounds that they do not believe their health and safety can be adequately protected may be making a protected disclosure. This could include, for example, concerns raised about workplace hygiene, social distancing measures, the provision of PPE, or even the risks involved in traveling to the workplace. Employers should therefore be careful about how these employees are treated, and it's not advisable to dismiss an employee who is refusing to return to work for this reason. Employers should instead take a reasonable approach to any complaints, explaining the steps that have been taken to protect health and safety and to try and reach an accommodation with the employee about returning to work. It's really important to bear in mind here that there's no qualifying service requirement to bring this type of claim. And what this means is that an employee does not have to have 2 years service to be able to make this claim. Looking now at health and safety dismissals, aside from potential for whistleblowing claims, employees also have protection from unfair dismissal on certain health and safety grounds under Section 100 of the Employment Rights Act 1996. This section covers a range of health and safety related dismissals, but the two most relevant ones here are: 1, a dismissal for leaving or staying away from a dangerous workplace, and that's Section 101, subsection 1D, and dismissal for taking action to prevent danger. That's subclause E. The first may apply when an employee is dismissed because they leave, propose to leave, or stay away from the workplace on health and safety grounds. An employee will be protected where they reasonably believe there is a serious and imminent danger which they cannot avert. The second may apply when an employee is dismissed because they take appropriate steps to protect themselves or other people from danger. Appropriate steps in this situation can include telling the employer that they believe there is a danger. Again, the employee must reasonably believe that the danger is sufficiently serious and imminent. So the employee's belief in either case is key. Whether the employer believes that there is a serious and imminent danger is not relevant. However, the employee's belief must be reasonable in the circumstances and based on the knowledge and advice available to the employee. For that reason, it's extremely important that an employer facing a situation where an employee leaves, threatens to leave, or refuses to return, or questions the safety of the workplace, takes the time to address the employee's concerns. The employer should ensure that it shares information about what steps it has taken to protect health and safety. For example, by providing copies of risk assessments or other planning documents. Once an employee's concerns have been addressed, that may bring the matter to an amicable solution. However, if not, the employer could argue that the employee's belief in serious and imminent danger is no longer reasonable in light of the information provided to them. These types of dismissals fall into the relatively rare category of automatic unfair dismissal. This means that if the employee can show that their dismissal was for one of the reasons I've just outlined, the dismissal will automatically be found to be unfair. The process followed by the employer and whether or not the dismissal was a reasonable response to the situation is not relevant. It's therefore particularly key and particularly important that employers consider whether the employee's belief in danger is reasonable, as this may well be the only defence it can mount against a claim. Again, employers should be aware that there's no qualifying service to bring this type of claim, so employees do not need the 2-year service to be able to bring this claim. Looking now at flexible working, the flexible working legislation does not create a right to work flexibly or part-time. It simply provides a framework through which a request from an eligible employee to work flexibly must be considered. However, acceptance of a formal request will result in a legally binding permanent change to terms and conditions. Requests for flexible working must be dealt with in an overall period of 3 months from the date of application, and that includes any time needed for an appeal of the decision. Once a formal application is made, further statutory requests cannot be made for a further 12 months. A formal request can be rejected, but important to note that there are only 8 specific grounds on which an employer can reject the request. For example, the burden of additional costs or the detrimental effect on ability to meet customer demand. Since the right to request flexible working is a statutory right, an employee can bring an employment tribunal claim if their rights are breached. Employees also have the right not to be subjected to a detriment for exercising their right to bring a claim under the flexible working legislation. It's good to know that an employment tribunal cannot question the commercial rationale or business reasons behind the decision to refuse a request. And neither can a tribunal substitute its own decision as to whether or not the request should or should not have been granted. So this severely restricts the scrutiny to which an employer's decision may be subjected. And so essentially the tribunal's role is restricted to reviewing the procedure followed by the employer, considering whether or not the request was taken seriously by the employer, considering whether or not the decision was based on correct facts, and considering whether or not the reason given or the reason for rejection given falls within the permitted grounds I've just talked about. However, an employer will need to at least show that one of the grounds applied, which may be difficult to achieve if the employee's role has been worked from home for a significant period due to the coronavirus outbreak. The tribunal can order employers to reconsider the application and may award compensation not exceeding 8 weeks' pay. And employees whose flexible working request has been rejected may also have grounds to raise a discrimination claim. For example, a disabled employee whose flexible working application has been turned down may argue that the employer has failed in its obligation to make reasonable adjustments. As I'm sure you all know, compensation for discrimination is unlimited, and the employment tribunal in these circumstances will be able to delve much further into the reasons for the employer's decision. These two factors make a discrimination claim potentially much more significant than a claim for a failure to comply with the flexible working legislation. And from my perspective, whenever I advise clients on this, I always say to clients that employees, disgruntled employees, will always stick in a discrimination claim here as well. In addition, if an employee is particularly aggrieved by the rejection of their flexible working request, then they could resign and claim constructive unfair dismissal. A failure to comply with the flexible working legislation or discrimination could give the employee grounds to succeed in a constructive dismissal claim. Finally, turning to change to terms and conditions, it's vital to remember that many employees' terms and conditions of employment are contractual in nature and cannot be changed simply because the employer wishes to make changes. In difficult economic conditions, many employees will be more likely and more willing to give their consent to changes in order to avoid redundancies, and seeking their consent to any change is the logical first step. However, not all employees will give their consent to a contractual change. Depending on the nature of the change, the reasons for it, and the numbers who are prepared to give consent, an employer may be able to impose changes on a resistant minority. However, this is not a step to be taken lightly. To force through changes without trying to get agreement would likely constitute a repudiatory breach of contract, which would allow employees to resign and claim constructive unfair dismissal. The alternative, and when I'm advising clients, I always say that this is a much better alternative, is to consult with employees about the change. But if the agreement cannot be achieved, to terminate contracts and immediately offer re-engagement on new terms and conditions. However, this route is still not without risk, as an employee could claim that the dismissal was unfair and could also give or claim wrongful dismissal if notice was not served on the original contract. A dismissal in these circumstances, or a dismissal following a failure to agree the change, will almost always be unfair where the employer has failed to follow any procedure and consult with employees over the proposed changes. It's therefore important to consult first fully with the workforce and then any unions if there are any. The long and short of it is, the more consultation that an employer can demonstrate was carried out before a change was made, the more likely the employer is to win any employment tribunal that may flow from the dismissal. Looking now at home working, the new normal working arrangements, new normal is a phrase I hear a lot about now, I'm sure you've heard it a million times as well. But the new working arrangements likely to apply across the country currently and in the coming months will undoubtedly involve greater degree of home working than before the coronavirus outbreak began. One of the earliest restrictions put in place was that employees who could work from home should do so. And it's therefore likely that this will be one of the last restrictions to be lifted. Even where jobs require some presence at a workplace, it's likely that employers will be considering whether that work can be staggered, so fewer people are in the workplace at any given time and are working from home for the remainder of the working time. With this in mind, employers should be mindful about IT and equipment. Employers should ensure that employees have sufficient IT equipment to carry out their role, and should also ensure that they keep track of kit that has been issued to employees. This is particularly crucial if IT equipment was taken from the workplace quickly at the outset of the lockdown, without time to take a log of company equipment that was taken. So employers might now want to consider carrying out an audit of what equipment remote working employees currently have and whether any additional kit is required. In particular, employers should bear in mind that working consistently from laptop computers can cause discomfort and back pain, so alternative arrangements may be required to reduce longer-term effects. Employers should also consider implementing or updating a company property policy to manage staff use of company property. Another thing to consider is how additional costs incurred by employees when operating from home will be managed. Employees are likely to incur additional telecommunication and energy costs because of home working. Employers may choose to reimburse staff for these costs and can pay employees an income tax and NI-free payment of £6 a week or £26 a month to cover reasonable additional costs. There's no need for the employer to justify this expenditure to HMRC, and the employee does not need to keep records of additional costs. In terms of communication, I think one of the key challenges for home workers and those managing them is to ensure effective communication is maintained. Communication can be much more difficult when working remotely, but employers should ensure that home workers are given the same information and opportunities for discussion that are afforded to employees in the workplace. Many organizations like yourselves, I know we certainly are already making really good use of the technology that's available to communicate while staff are working at home. For example, through video messaging apps or websites, direct messaging tools, and of course, traditional phone and email. However, if full or partial home working is to be effectively managed on a longer-term basis, employers should consider setting informal guidelines on how each communication tool should be used. This could, for example, include when direct messaging should be used in place of email, when group emails are appropriate, when and if meetings are required, and how matters should be escalated. Managers should ensure that they give all employees the opportunity for face time to discuss work and to catch up on well-being. We communicate in a vast range of emotions through facial expressions and body language, and it can be difficult to pick up on cues when communicating in writing or by phone. While opportunities for frequent check-ins present themselves easily in the office, this is not likely to happen so readily while working remotely. Managers should therefore consider scheduling regular face-to-face meetings or designating specific times of the day for remote, open-door video call sessions. Well, what about effective remote meetings? Remote meetings can present new challenges for the meeting organizer and participants alike. I don't know about you, but it took me a little while to adapt to this new normal. But I must say that I do find the remote meetings to be a really effective way of communicating both with my colleagues and my clients as well. One way to be effective is that the meeting organizer should first consider whether a meeting is required or whether an alternative form of communication would be more effective. Practicalities of the meeting should be considered. For example, ensuring that all participants have access to software and are able to use it. A good way of making remote meetings effective is to ensure that each meeting has a leader. The leader may want to implement rules to make sure that communication flows smoothly, for example, by asking everyone to join on mute to avoid background interference, and also implementing a hands-up system to ensure that everyone can participate in the discussion. Leaders should be clear about the purpose of the meeting and any pre-work that may be required. Consider creating and issuing an agenda with a clear purpose, desired outcomes, a decent amount of time in advance. The meeting leader should also keep the meeting on track by ensuring that the agenda is stuck to as closely as possible. And if the discussion strays into irrelevant matters, try to bring that discussion back on track. Capture and park topics that need to be addressed, but not perhaps at that meeting. Arrange follow-up sessions if appropriate. Managers or leaders can also encourage attendees to share their thoughts and ideas, particularly from those who aren't forthcoming with their own. Clarify outcomes and actions to ensure the owners of the actions are clear. Share meeting outcomes with the other stakeholders and who should be kept in the loop. In terms of meeting participants, attendees should familiarize themselves with the agenda in advance and do any pre-work. They should keep the meeting running smoothly by being on time. Thank you everyone for being on time this morning. Not interrupting everyone and being patient with technology issues, including delays which may cause the speaker to be unexpectedly interrupted. The role of the meeting leader should be respected, and participants should not take attempts to keep the meeting on track as a criticism. Attendees should be encouraged to contribute their thoughts and ideas, speak openly and ask questions. When contributing, participants should try to avoid repetition and try to keep input brief and to the point. Participants should remain open-minded and actively listen to others in a genuine attempt to understand other people's perspectives and views. All contributions should have a positive force and not a negative one. Most video conferencing tools also have a built-in chat function. This can be a pretty useful tool when used well, but participants should be discouraged from having side conversations so that others are not distracted. Working from home whilst others are in the household, including children and animals, I know from personal experience can be quite a challenge. So participants should be understanding and patient if calls are unexpectedly interrupted. What about motivating a remote team? How do you motivate a remote team? Keeping a team that is used to daily interaction motivated while working remotely can be difficult. However, there are various ways in which managers can try to keep their team motivated, even in these challenging times. A particular key in maintaining motivation and maintaining good working relationships is trust. Employers should trust that employees can and will work effectively from home. Keeping tabs on performance is expected, but managers should avoid micromanaging employees and seeking constant updates on work. That being said, managers should also take proactive steps to deal with underperforming employees, both to ensure that the work is completed and to make sure that frustration does not build up within the team. Managers should be clear with employees about what tasks they should complete and the timescales for delivery. Most employees work more effectively when they feel that they're contributing to a meaningful strategy. So communicate effectively about the purpose of the tasks the employee is being asked to do and how this fits with the organization's overall goals. Ask employees for input about how they carry out their work and encourage them to seek innovation and share new ideas. Recognize when work is done and give feedback, both positive but also constructive. Employers should also consider how employees can be effectively rewarded for going above and beyond, particularly if they're facing increased workloads or more difficult working environments because of the current situation. Employers should ensure that employees continue to have opportunities for development and learning, so managers should ensure that they take time to discuss development goals and facilitate opportunities. Finally, I'd like to touch upon mental health. The coronavirus outbreak has created major uncertainty which may cause challenges for people living with anxiety, stress, or anxiety-based depression, especially those that have health anxiety. This may be exacerbated by worries around job security, financial responsibilities, caring for vulnerable relations, and managing family responsibilities. As a result of social distancing and social isolation, many people don't have access to their normal coping strategies, such as exercise, seeing family and friends, etc. And this can further increase feelings of anxiety. One of the main things employers can do is to maintain communication with employees working from home and to listen to their concerns. Support employees who ask for help if they need it and reassure them that it's okay to feel anxious, as many others will be feeling the same way too. Understand that some people may have real concerns about catching the virus, while others may have worries about family or friends. Keep employees up to date with your organization's policies and contingency plans to help reduce anxiety. It's important to strike the right balance between your organization being prepared for the significant spread of the virus whilst reassuring people that there's no need to panic. Ensure that line managers are regularly informed about the organization's contingency plans and how to discuss the situation with any concerned employees, and where to signpost people to go to for further advice or support, including any employee assistance programs or any counselling if they're anxious. Promote the resources you have available to support employees' health and well-being generally, including those through an employee assistance program. Finally, for my 2 cents worth, share some of these top tips with your employees to help them manage their mental health while working from home. These are rules and guidelines I try to follow. So create a routine. Get up in the morning at a set time, have your breakfast and be at the desk at the same time every morning. My routine is very much what it is when I come to the office and work. I like that routine. It keeps me focused. Take regular breaks and exercise. Get up from your workstation every 25 minutes. Go for a walk. Stretch. Speak to people. Skype your friends. Take a break. It's really important. Get comfortable. You might not have the best equipment at home. I think my seat's a little bit too small and my desk's a little bit too high at home. But try and get as comfortable as you possibly can. And find a good place to work. A good, quiet place, if at all possible. Remember to eat regularly and try to avoid the salty and sugary snacks. It's difficult, I know, but try to avoid them. Try to eat as healthily as you can. And finally, try to minimize distractions. We all work best when we're focused on one thing. Move your personal phone out of the way. Try to work away from anything that could distract you. The TV, the pets, children, whatever it may be. So that concludes my part of the webinar, and I'd like you now to meet my colleague Douglas Cameron, who is currently socially distanced. I'm going to pass you over. So thank you for your time this morning.
Good morning, everyone, and I'd just like to make the point, I presume you all noticed the employment law left the cleaning up to the health and safety manager. That will be noted. But seriously, Jerry, thanks for a very interesting session. I personally thought it might be an idea, before discussing the specifics of safety and COVID-19 with the potential return to work, or in the case of a number of our colleagues in England, the actual return to work in a number of sectors, that we perhaps have a quick reminder of the main safety legislation that is applicable, which has not changed, but perhaps is even more important in the current climate. In this slide, I've tried to briefly show the main requirements as I see fit in terms of the Health and Safety at Work Act. Section 2, the responsibility of the employer to ensure the health and safety and welfare of all his or her employees. Section 3 extends that responsibility to persons not in their employment. So in most of our cases, that would be visitors to our businesses and or our customer base. And Section 4 is interesting, perhaps best explained by premises occupied by tenants, where we have landlords or managing agents. They usually have a responsibility for communal areas. So moving forward, we need to consider that as part and parcel of any COVID risk assessment process. And Section 7, I think, is going to prove to be very interesting moving forward. It is, as you can read, the requirement for employees to support their employer's efforts towards safety in the workplace and to take reasonable care of both themselves and other persons who may be affected. So it's important looking forward in terms of COVID-19 and businesses that are already endeavouring to return to work, that employers have carefully thought through all aspects of risk and created what we're calling a secure and safe workplace in order that employees can be confident and in turn understand procedures and play their part. The management of health and safety at work regulations, and if any of you really need to know where the main requirement for risk assessment sits, and you're looking at Regulation 3. The requirement for risk assessment for employees and anyone else who may be affected. May I add that the regulation also mentions the need for review, and I think we can all agree that COVID-19 has presented every business with that change and challenge. So existing risk assessments may require review. The risk assessments must be recorded when more than 5 employees are present, and should be completed in conjunction with employees or their representatives. I'm going to return to that a little later. Elimination of hazards is primary, then risk reduction by control. And in the case of coronavirus in the workplace, each control measure should either prevent potential transmission, reduce potential transmission, or even reduction through destruction. During my rather lengthy career in this world of safety, I've probably had no more serious risk assessments than the ones I'm undertaking currently to support business. And absolutely no shortcuts should be or can be taken. It's down to careful consideration and precise details. What I don't think will happen are risk assessments that maybe have control measures along the lines of increased cleaning to be arranged. No detail. Suitable and sufficient screens to be provided in the factory production area. No detail. Or the best one I just read yesterday, communal areas responsibility of landlord. Tick, move on. Not so sure. Regulation 7, businesses must have some expertise involved in the process. Now, I'd love to say that should always be me, but the reality is it could be a person with sufficient business knowledge and sufficient knowledge relating to COVID-19, perhaps using the vast amount of current guidance that's out there for our consideration. I am pleased to say, however, my team are busy, and I was told this morning one of them is suffering from risk assessment ititis. Regulation 8 is interesting and one I'm still mulling over. There's a subsection in that regulation that states that an employee who finds themselves in a place of imminent danger shall remove themselves immediately to a place of safety. And I'm sure you can maybe consider the ramifications of that in terms of COVID, where an employee is perhaps not happy. And as an aside, we heard Nicola Sturgeon on Tuesday during her briefing, supporting employees who have a concern to report, confirming their employment rights. I personally would have rewritten her script to make mention of their workplace safety rights instead. And finally, Regulation 10, which I think is straightforward, but most important as we potentially return from lockdown. And that is the provision of clear information for our employees regarding their health and safety, identified by the assessment, and the preventative and protective measures that are being brought into play. The subject of PPE it seems to be never off the news, so I'm going to try to put some perspective on it. Personal protective equipment regulations apply to the workplace. Regulation 4 requires employers to ensure suitable personal protective equipment is provided to his or her employees who may be exposed to a risk to their health and safety while at work. The important aspect to recognise here is where the risk can be controlled by other equal or more effective measures. That's the route we should follow. Personal protective equipment is the very last resort. So a physical screen between two people is more effective than them wearing face masks. Regulation 6 is the requirement to carry out that risk assessment to identify work tasks that may require personal protective equipment. But I found it doubtful that many employers will be able to source what is termed an FFP3 face mask and arrange facial testing for all employees and have sufficient stock to replace after use. And I don't need to tell you, we're all aware where, quite rightly, that face mask protection is heading for our frontline services. So my advice in terms of workplace activities is to endeavour to avoid the need for face masks, come up with a better solution, and that could be social distancing and or physical separation. And going back to Nicola Sturgeon's comment, if I may, shortly after that, the government announced a £10 million bonus for the Health and Safety Executive. That is to bring in additional staff to their call centres, provide additional inspectors and relevant equipment. And under a Freedom of Information Act request 2 weeks ago, the Health and Safety Executive confirmed that since the first COVID-19 outbreak in the UK, they have received 4,500 complaints. We presume that would be in the main from employees, and that's not taking into account other complaints that may have gone down the trade union route or into local authority environmental health. But sticking with PPE, I don't think we can move away without mentioning the government's comments relating to face coverings while employees travel to and from work. I'll clarify the reason. I'm sure we all know it's not to protect you. It's actually, if you're wearing a face mask, you're protecting against me. And of course, there are very many different types out there. Some, in my view, should be winning fashion awards for their style. And I do support the wearing of them in public transport, whereas we've seen in London, social distancing is and will potentially continue to be a concern. I'll let you know that in my experience over many weeks, I'm seeing more and more employers recognising the concerns of employees using public transport and have made the decision to buy in bulk reusable face coverings. However, delivery times are difficult. 6 to 8 weeks is commonly what I'm told. And I'm sorry, we all know the cost has increased. But perhaps something for you to consider to alleviate the fear that some employees will have using public transport. And finally, Regulation 7 relates to the replacement and maintenance of personal protective equipment. So as we know, it's not a one-off buy, it's a constant reordering, potentially longer time periods the more people go back to work. So again, my vote is, it's there, but let's try and come up with control measures that can avoid the need for personal protective equipment. So, risk assessment process and coronavirus. This slide, hoping you can all read it, shows some key areas I think most businesses will have to consider. And below the key headings at the top, I've provided some actual control possibilities under each heading. I'll give you a few seconds to quickly scan through it. You're getting the presentation anyway, so you can tick that box. But a very good place to start the process in using those headings and filling in potentially what we would be looking at for control purposes. 3 other headings with, again, similar potential control measures now appearing in. So this is how I would personally start a first stage risk assessment. The risk assessment itself would require further detail, but this is, I think, a good starting point for businesses to consider, because this is not an easy gig. This is probably the hardest, as I said earlier, the hardest risk assessment process that I've been involved in my career. You'll notice at the bottom of that particular table, there is a website. For those of you that perhaps don't know, that is the website that you will find the 8 return to work safety-related guidance documents issued by, and I'm not sure if I'm saying UK government in brackets England close brackets. However, they were made available on Tuesday. Interesting enough, when you read the guidance documents, they do mention that the original documents were brought in conjunction with Scottish, Welsh and Northern Ireland governments. The reason I'm mentioning that is in Scotland, Wales and Northern Ireland, we have an opportunity because there is a timescale on our side. We probably noticed that England didn't really get so much time to take the guidance, prepare and return to work. So my advice is, if any of those current documents and guidance are available and appropriate to your business, grab them now. Others will follow, I'm sure, but this gives us a really good starting point in development of a risk assessment process. On reading the guidance documents, which does keep me up late some evenings, interesting to note that each one of them offers a poster that businesses can download and put in their front window to say we are COVID-19 secure, the presumption being because we followed this guidance. Now, I think that's a choice for businesses. What's perhaps not a choice is that the government has suggested an expectation that businesses with over 50 employees should publish their risk assessments on their company website and share with employees. So you remember earlier I said I would come back to this integration and involvement of employees in the risk assessment process. The government has re-emphasised that. So how might a risk assessment look? I've taken a couple of snapshots. Initially, we would approach it as think about the building. One of my colleagues who's probably listening in phoned me yesterday on a return to an office to find that there had been a leak and we were minus a kitchen ceiling and I think half a gents toilet. So these buildings have been lying dormant for some weeks. So my first suggestion is let's take together and do a building assessment, a pre-opening audit. Now this particular snapshot of what is, I'm sorry to say, a fairly lengthy document, is endeavouring to cover all existing safety requirements so nothing falls through the net. If I give a couple of examples, water hygiene. We've got water tanks and water systems that have been lying dormant for weeks. So how are we going to recommission that? Because the last thing I'm sure we'll all agree is we certainly don't want a Legionella outbreak on top of what we're trying to deal with COVID-19. Just another little snapshot, this one covering more fire safety issues. And a common question we're being asked, which I promised I would cover, is what happens if the day after I closed the building down, I was due a statutory inspection of perhaps a lift or something similar, and it hasn't happened. So the lift is beyond its sell-by date in terms of statutory inspections. And the advice we've given each business and will continue to give each business is, first of all, keep hassling the inspectors to get the inspection done. And as you call them, record it. So you can show I spoke to Bert at whatever inspection firm on such and such a date, and he told me he would get back to me when he's got sufficient staff to carry out the inspection. Let's check the previous statutory inspection. Was it satisfactory? Was the previous one satisfactory? Do we have an ongoing maintenance agreement? Let's have a look at the maintenance reports. Are they satisfactory? You're probably getting where I'm going here. I'd like the word satisfactory. And we run the risk because we feel it's surviving and it will survive, but we keep chasing the various inspection firms. It's either that or we switch off a lift serving a 30-storey building. So I think in terms of assessment, we have to take these abnormalities into account. And I work with ex-enforcement officers and we're all in agreement that there's got to be an element of flexibility by enforcement, understanding the pressures that businesses have been under during this closed down period. So moving on away from business to the activities within the workplace and how might an assessment look. I've just taken again a few snapshots, basing it on the detail of the risk assessment process. So you can see here we're looking at the activity. We've named a certain company you might know. We've dated it. We're going to review this pretty frequently. This is not one that we can say we'll look at it in 12 months, we'll look at it in 6 months, we'll look at it. Some businesses I'm working with are sitting and reviewing it with their COVID protection team daily. And you'll see that I've just dropped in the regulations, sorry, the Act and the 2 sets of regulations that we talked about earlier, and I'm identifying in this particular instance who I believe could potentially be affected if this risk assessment and controls are not correct and in place. Next section, we're considering a step-by-step workplace activity, and I would always suggest that we extend the risk assessment to home life, to travelling from and to work, and any other non-direct work activities where we feel the risk assessment will be of benefit to our employees. Because remember, the risk assessment has to be shared with employees. That's what the legislation requires, and government has re-emphasised it this week. So I think the wider the assessment, the more benefit it will be to the employees. Please, I'll try and explain quickly risk rating. The L stands for the likelihood and the S severity. So you will probably see on the next slide that those figures are slightly higher in the workplace because we believe with the stay-at-home situation that we're faced with, that the risk of cross-infection within home life is relatively low. If we teach, and let's be honest, I would suggest 90% of employees are pretty switched on when it comes to this bit. But as an employer, if we're reminding them, we would hopefully then look to the right-hand column and suggest by reminding staff that the likelihood has reduced slightly. And you'll maybe notice in red there, this suggestion that a special risk assessment should be completed for high vulnerable type or vulnerable or moderate risk type employees. And that's something that we've worked up for offer to businesses. Another little snapshot, and I thought I'd give myself an easy one, so we decided to take an office. Again, if we look at the columns, you can see that the risk assessment, risk factors at 12. I'll be showing you the matrix on how that's calculated just in a second. And if you look over to the right-hand column, the suggestion is that if, as you're reading through those controls and or actions, the likelihood when all these controls are in place, monitored and reviewed, the likelihood should be less. And in this particular assessment, the business was honest because the red type is actually what they still needed to do during that risk assessment process. And a risk assessment with actions still to do is a legally acceptable document. We all know out there there's too many risk assessments that you read and they're all signed off and it all seems to be ticked to do. Please use this as a work towards assessment. We have numerous companies, and we're using the phrase ping pong, where we start the assessment process, we ping it to them, they ping it back to us. And you know something, after about 4 or 5 pings and pongs, we end up with a pretty good, robust, detailed assessment, which I would advise you to take as what will be required and expected. So, risk matrix. There are other well-known ones on the market, but this is the one we tend to use. So if you can recall the numbers we used, you won't be surprised to know that we're heading into the sort of top right-hand corner on a pretty regular basis, and we're not really moving very far away from that top right-hand corner because we simply can't. We can reduce risks slightly. So in summary, the risk assessment must be very detailed in terms of documentation. This process will take time. Please, as one of my colleagues sent me just a few days ago, do not pull one of these free assessment templates off the internet. I have 4 sitting on my desk at home, and I'm shocked that anyone would have the gall to put something like that up. It's going to create this false sense of I've got a document, it must be legally compliant. I can't see that being the case here. Employees are going to return to work. They want to see robust, well-drilled assessments that will make them feel comfortable and safe. If they don't, I suspect they will pick up the phone. And we certainly don't want to be involved with enforcement. We've had 1 or 2 run-ins already, and I'm glad to say that we got out of it, both myself and the client, very well, but they ask a lot of questions. So, on assessments, we're happy to help anyone moving forward. I'm pleased to know I'm nearly finished, and I'm actually going to stop on time, which pleases me immensely. I wanted to touch on home working. A number of you have spoken to me about home working, and we were pleased that the Health and Safety Executive took a stance and issued a statement on home working when the lockdown started. And that was they deemed that home working, what I call full-blown top-to-bottom assessments, would not be required during a temporary situation. And we assumed that the temporary situation was the COVID lockdown, the home isolation, the working from home. I'm going to watch this with interest because as more and more businesses are encouraged to return potentially to the workplace, and businesses may decide to then leave staff, employees on a more permanent basis at home, I think we would have to look at the home working assessment and, dare I say, ratchet it up, because it's not potentially going to be deemed as a temporary situation. However, in short, we'll keep an eye on HSE, because I won't be suggesting until HSE remove the word temporary. And finally, both my team and the HR and legal teams have produced a return to work toolkit. This contains all the advice and resources you need to plan a return to work. This is available free to all law clients and is sitting on our on-client area if you haven't grabbed it yet. The toolkit contains useful resources. I've got a list, I've been told to read them out. Return to work assessment, shutdown contingency plan, return to work HR guide, return to work legal risk guide, end of furlough letter, return to work questionnaire, and a home working guide and policy. Now, if you're not a law client, you probably know what's coming, you can purchase it. On the same link that you've come into this session today, for a fixed fee of £395. That includes a 30-minute telephone consultation with one of our employment lawyers or our HR consultants. And it says here, and even help with risk assessments from my team. I've noticed that questions have been pinging in, so I have been asked to say that all questions have been received. Jerry and I will be working on direct answers with you all over the next few days. We're nearly done. Final things to say on behalf of Jerry and myself. Thank you for your attendance, and please stay safe.